series that we've been having for the last 2 months. During the lockdown, we have a series of workshops and webinars organized by SINE. And today we have with us Arjun and Raddhika. And the theme that we'll be focusing on today would be on IP as an asset. That will be the main theme that we would be discussing. How can you maximize your company's valuation and portfolio using your IP as a tool for increasing your valuation as an asset? And there'll be various things that we would like to impart through this webinar, mainly on minimizing IP risks, identifying IP assets, protecting your IP, preparing for IP due diligence, increasing your IP valuation, and preparing your exit strategy. So for that, we have with us, firstly, I'd like to introduce Arjun. So Arjun is known to us, known to SINE for the last many years. He is also an IIT Bombay alumnus and a registered patent attorney and a certified patent valuation analyst with 16 years of experience in patent prosecution. He has worked as head of Indian operations for a US patent law company, closely working with Silicon Valley startups, VCs, and tech MNCs prior to founding his company Metayaj IP LLP in 2006. And at Metayaj, Arjun and his team have got over 100 US patents granted for their clients with a success ratio of 92%. Welcome, Arjun.
Thanks a lot, Rajesh. It's a pleasure to be here.
Next, I'd like to welcome and introduce Radhika Singh. So Raddhika is an intellectual property and commercial lawyer and startup advisor. She has 13 plus years of experience with leading firms in India, specializing in IP, commercial and technology law. And she has worked with tier 1 law firms such as KNS Partners, Luthra and Luthra, etc. And have advised over 250 startups on various legal compliances and policy requirements. And she has also negotiated contracts in behalf of leading authors of India for licensing firm rights of their books with leading production houses such as Yash Raj Films, Viacom, Ad Labs, and Star Plus, to name a few. She has an LLM in intellectual property law from King's College, University of London, and an LLB from Delhi University. Welcome, Raddhika.
Thank you so much, Rakesh. Thanks a lot.
So the format would be like this. We will start with Arjun. So he will take us through his presentation and some of the key takeaways he has for this particular webinar. And he will also try to share some case studies. Along with that, please, I'll also request the participants. So we have close to 60 participants now, and we will request you to post in your question and answers in the box that is there for Q&A, and we will try to address those as and when during the session for the next 1 hour. Thank you so much, and over to you, Arjun.
Are you able to hear me, Rakesh?
Yeah, and we can see your screen as well.
Awesome. All right. So a little more about me. I studied at IIT Bombay, as Rakesh mentioned. So I started my career at IIT Bombay's Tech Transfer Office, which is the IRCC. So long back at the Dean R&D office. And so very much closely related to IIT Bombay. So I'm also an inventor on 2 patents. I've applied for some patents, and I myself am in the process of doing a startup. So that's how I'm also on this journey towards, protecting my IP and commercializing. So that's how I can relate to what all of you are doing right now. So let me start off by talking about active income versus passive income. So how many of you have heard of this guy, Robert Kiyosaki? So he's written a lot of books, the most famous one being Rich Dad, Poor Dad. So he says the difference between his, his rich dad and his poor dad is that his rich dad understood what an asset is. An asset is something that puts money in your pocket. So an asset is something that helps you to generate passive income, where your money is working for you. So people who don't understand what an asset is and how to leverage it, they rely primarily on active income, where they need to work for money. That if they stop working, there's no income. So that's the difference between active income and passive income. So in today's session, we are talking about intellectual property, and it's an asset and how it can help you achieve your business goals, including generating passive income for you. Intellectual property is anything that's created as a result of intellectual effort. But then there's a wide variety of intellectual property. So it could start from, for example, your company's or your product's brand identity. There could be something unique over there which distinguishes your company, your products, your services from that of your competitors. It could be in the form of any technical features in your product, any technology-based innovation. It could be in the form of the external appearance, the shape, the surface ornamentation of your product, which is visually appealing. So it's like if you have two products and one looks really aesthetically pleasing, it looks really cool, visually appealing, versus another one which looks very standard, right? Very boring, very monotonous. Consumers have a preference to buy the product which is more visually appealing. So, or is it like your company, your people have access to some specialized knowledge, some data, some secret sauce, right? Which gives you an edge over your competitors. Or like in today's world, there's so much content, right? Whether it's in the form of videos, sound recording, blog posts, written articles, right? All these things can differentiate your company, your brand, your product, your content from those of others. So all these are forms of intellectual property. And that's why I call them the X factor, because they are capable of helping you stand out from everyone else in your industry. And each of these different aspects can be protected through different forms of intellectual property rights, such as trademarks, patents, designs, trade secrets, and copyrights. So this process of, if you're an entrepreneur, you've come up with some, something which you think is unique, which you want to take to the market. What are the different stages that you have to go through when it comes to taking your IP, which is your intellectual effort, from idea to exit, right? So the first step would be to look at what you have today. Like, what are the different forms of intellectual property? Like I mentioned, is it something which is different in terms of the functionality of a product, the aesthetic appearance? Is it your brand name, your identity? Is it any of those aspects? You identify what IP you currently have, right? And then you see, okay, is this something which has got potential in that industry, in that market? What are people in that industry, in that domain? What are they doing? Where are they investing their R&D budget? What are the problems they are trying to solve there? And then you optimize your research and development efforts in such a, so you focus your resources on solving those problems that have the most commercial value and the biggest impact. So that is called R&D optimization. And then once you have optimized your R&D, you have identified what IP you have. The next step is to protect it. So in the form of registering your IP rights, whether it's patents or copyrights or trademarks or designs. And finally, how do you make money from that? How do you leverage that IP to achieve your business goals? So one such way is through licensing and generating royalty income. So let's talk about how IP strategy, which goes beyond IP protection, right? IP strategy helps you to achieve your business goals. So what are some of the business goals that you may have as a startup, right? So the first thing that you might be looking at is survival. So the first thing you might be thinking about is like, I have an idea. How do I even like build my MVP? How do I take it? How do I talk about it to potential customers? How do I talk about it to some potential partners, to employees, to investors, right? And often you may have a concern, like how do I do all these things, but still ensuring that my IP is secure? So that could be one such immediate challenge you may have in a very early stage. Going forward, you'll be preparing your business plan, right? So that time you'll have to look at these questions like, what are your strengths? What are your weaknesses? What opportunities are there in that market? And what are your threats? Who are your competitors, right? Or you may be looking at whether you yourself can create barriers to entry for your competitors. So all these things go into your business plan. And then one question that you're going to be asked very often when you're talking to potential customers or investors or mentors or all kinds of people, right, is what exactly is your value proposition? and how is it different from others in that similar market or in that segment, right? So you need to have clarity. So just saying an answer that, my product or my technology is totally unique and there is nothing like this in the entire world. Whereas, we hear this kind of statement very often. When you actually do the research, we find out that that is very rare. In most cases, there is something very similar. And then it comes down to distinguishing yourself further and differentiating yourself from what is already there. And then the next thing that you might be looking at is how can you increase your valuation? How can you secure your IP for the purpose of fundraising or for the purpose of generating royalty income? So that is another thing that IP strategy and IP protection helps you to do. It helps you to actually ensure that the value of your company goes up. It's not just that, some people have created something which has got value, but that is not linked to the company and it is not protected by the company or owned by the company. And so it doesn't get accounted in the valuation of the company. And finally, how do you develop this kind of culture in your organization that encourages the people to constantly innovate and where they are rewarded and recognized for innovating, right? Like some of the greatest companies in the world, like Google, they are known for their culture where their employees are encouraged to innovate. That's why some of the smartest people in the world, they love to work for these companies. So can you create that kind of culture to sustain innovation in your company? So that's where patent strategy plays a role. So I don't want to get into the very basic things, but since we are going to talk, one of the key aspects that we want to cover in today's session is minimizing your IP risk. So if you are a company that's selling products in a like it could be in India or it could be in various other countries, it could be in the US or China or the Middle East or anywhere, right? So what you want to know is once you launch your product and assuming it starts doing well, what if some company sends you a legal notice saying that your product is infringing our IP, right? So I'm going to talk a little more focused on patents, whereas Raddhika is going to address some of the other IP rights and the IP risks related to those. So specifically, I'm going to talk about something which is called a freedom to operate search, which you do if you have a product which uses some technology, right? Some of it may be developed in-house and some of it may be an extension of some existing technologies which are already there in the market. So how do you find out if your product is infringing somebody else's IP? So the answer is that the simple thing that you can do is you can do a search on the patent databases. So patents are country specific. So if you're launching your product, for example, in the US market, then you need to search on US patents and see if any of those US patents claim something which is there in your product, right? So you need to compare the claims of those patents in that country with your product features and see if all the claimed elements in that patent are present in your product or not. And if the answer is yes, then there is a chance that your product is infringing their patent. And when you know this, how do you minimize your IP risk, right? So if you are already aware that your product is infringing a particular patent, right, then we have to tear down that patent, go through the claims, interpret it in light of the specification, go through the prosecution history, and see whether the claims are actually covering your product or not. And then we can look at reverse engineering. We can look at what are the elements that we can modify in your product in such a way that it no longer infringes that patent, right? So that is how you can minimize your IP risk. So that it takes the ability and the skill to search for patents, to identify all the patents that your product might potentially be infringing, and also read those patents, go through the claims and see if to what extent there is infringement. And finally, reverse engineer, right? So that's how you minimize your IP risk. And one common misconception that people have is they think that they have applied for a patent or that they may have even got a patent. So they think that they are perfectly clear and that they are not infringing anybody else's patents, right? That is far from the truth. Because if you do a simple patent search, right, you will find that there will be at least 5 or 10 different patents which are granted, which look very similar to each other. So it's very much possible that each of those 5 or 10 different entities, they have their own narrow specific patents, right? But they could also, when they launch their product, they could be infringing on the other patents. So merely having a patent or applying for a patent doesn't protect you from IP risks of infringing other people's patents. Okay, now let's talk about how you position your startup for an exit. So, of course, a lot of the startups are formed by identifying a problem themselves. And often I'll tell you, including for my startup, the problem is usually identified because one of us is facing the problem ourselves. So maybe like you might have heard the story of how Fanindra from Red Bus, he couldn't get a bus ticket on Diwali, and so he started Red Bus, right? Or you might have heard a lot of entrepreneurs talking about that. Many of the healthcare entrepreneurs have themselves seen one of their loved ones having a problem due to a disease, and then they come up with some innovation to solve that, right? But then that is one way of identifying problems. But that doesn't guarantee that your problem is big enough, or that it has a market, or that even if you're successful in building a solution to that problem and building a startup, right, which can commercialize a product based on that, is the market big enough? And are there any companies which are actually looking to potentially acquire your startup? Because let me tell you that if your startup is looking for investment from, say, angel investors or VCs, then they are looking for an exit, right? And that exit is most of the time, most probably not going to come to you through an initial public offering. There are very few tech companies, especially in India, who have actually gone on to an initial public offering. So the most common route for investors to get an exit is an acquisition. So if you want to raise money from investors, you've got to tell them what companies are likely to be interested in acquiring your startup at some stage down the line, right? And why? So that is something that you can predict, because if you do a patent search in your tech domain, right, you can see what companies are applying for patents in that domain, B, what kind of problems are they trying to solve, and what kind of problems are they investing a lot of money in research as well as in patenting to solve, right? If you have access to that knowledge and you focus your research efforts on solving those problems in a better way, and you also get patent protection for your improved solutions, right? Then you also know that those large companies who have already invested a lot of money in trying to solve those problems are likely to be interested in partnering with your company, or they could become potential customers, they could become potential licensees, or even down the line, they may be interested in acquiring your company. A question that a lot of you may be wondering, right, is that I have an innovative technology, I have an idea. Now, should I apply for a patent for it, or should I just keep it as a secret? You know, if I don't tell anyone, no one is going to come to know. Or should I just publish a paper on that, right? So this is a question that a lot of you may have. There are pros and cons of each, and you can also adopt a combination of 2 or more of these. So they are not mutually exclusive, but then you have to understand in what order you have to do, what you can patent, what you can keep as a secret, and what you can publish. So that is something. You can do all of these, by the way. So you can patent something where the criteria for getting a patent basically is that you need to be able to describe how to make, use, or sell your invention in sufficient detail to enable a person of average skill in that technical field to implement it without undue experimentation. So you can disclose as much detail as required to get a patent, but everything else, right, you can keep as a secret. what you can also do is you can first file a patent, and once it gets published, you can publish a paper also. Because if you file a patent and then publish it, then the publication doesn't affect your chances of getting a patent. But if you do it the other way around, then you may lose the right to obtain patent protection. So again, looking at the pros and cons, right? So you might say that, okay, I want to keep it as a secret, right? And you can rely on non-disclosure agreements, right? So that's great. So if a external entity is willing to sign a non-disclosure agreement, you should definitely try to get it signed, right? But one challenge that entrepreneurs face is a lot of other entities whom they may have to disclose certain information, like confidential information. They are unwilling to sign non-disclosure agreements. And in many cases, it makes sense for entrepreneurs to not insist on signing NDAs for business reasons. So in that case, the only way you can protect yourself is to have a registered form of IP, such as a patent. Also, there is a risk. Say, if you keep things as a secret and somebody else comes up with the same invention and they get ahead of you and file a patent, right? Then they may get that patent granted and they may stop you from using your own invention. But at the same time, patents are not completely foolproof either. Because like I said, it is possible for somebody who's really skilled in understanding patents and claims to break down your patent into elements and to reverse engineer it and to try and avoid infringing your patent. So in order to ensure that your patent is going to be strong enough that even if some of the world's best engineers and patent attorneys sit down and try to reverse engineer it, they still will not be able to get away, right? They still end up infringing one or more of your patents, right? So that is why the way the patent is written and prosecuted is very important. And of course, you can, if you don't have a commercial interest, you can publish it and you can focus on going to the market. But that will result in dilution of the value of your company. Now, the next question is like, where should I patent, right? A lot of people have this idea. They say that I am an Indian resident or an Indian citizen. Some people, I have even seen in the questions that some people said I'm a US citizen, right? So, well, the question of like where to patent, right? It doesn't depend on which country you are resident in or which country you're a citizen of. There are only some considerations in terms of which country to apply in what order, right? Depending upon your country of residency or where the invention was conceptualized or where the company is incorporated. So these things affect the patent filing strategy. But keep in mind, any person or any company, which is registered or resident anywhere in the world can apply for a patent anywhere in the world. So given this fact, right, that there is no such restriction, where would you want to patent your technology? You would want to patent it where there is a market and there is maximum value for your technology. And you have to keep in mind that patents are country specific, that just by applying for or getting a patent in India or in the US even, it doesn't mean you have rights anywhere in the world. So for example, I know a very successful company which has raised lots of rounds of funding, but they have applied for patents only in the US. They've not applied in any other country. Whereas it's great that US patents have a lot of value. It makes sense to patent only in the US, right? But then at some point, they're looking at getting customers, in Southeast Asia, in Europe, in Middle East, in so many other countries, including in India, where the market is really opening up. Then they find that they don't have any patent protection and they are running against our competitors who have got a lot of money and resources, right? So you've got to keep in mind that if you're thinking big, you're thinking global, you've got to have an international patent strategy. So I talked about it, like we suggest to deep tech startups, like where there is no like kind of restriction, the technology can be applied in multiple markets around the globe. If that is the case, I'm not saying suppose it's a very niche market and it's there only in one particular country, like say South Africa, or in, it's only relevant in India, for example, right? So then you can consider applying only in those countries. But assuming the technology can be deployed across the world, there's no geographical restriction on the relevance of the technology or the market, then I would say try to patent in the US. Why? Because the value of the US patent is likely to be quite high, among the highest, right? And having a US patent definitely increases the brand value of your company as an innovative company. And once you get a US patent granted, using the patent prosecution highway, you can expedite your patent examination in 25 countries. Having US patents gives you leverage in negotiations, including with large companies, because even large companies know that US patents are enforceable and they take them seriously. Let me give you an example. The University of Wisconsin sued Apple for infringing one of their patents related to a chip, which Apple was found to be using in their iPad. And guess how much damages were awarded to the University of Wisconsin? Almost $500 million. So that's the kind of damages that you can get from enforcing your US patents. And there's a wide range of patentable subject matter. So a lot of restrictions, you will find restrictions in India. They can be overcome, right? But in the US, there are fewer restrictions on what can be patented. And like I said, there's a robust enforcement system. The last slide I'm going to show you is this patenting cycle process, right? So I'll just quickly go through this. It's like, as a startup, you might have heard there is something called a provisional patent application. It makes sense for a lot of early stage startups to file a provisional, simply because if you're doing it for the first time, you might want to give it sufficient time. You don't want to rush to do it. And you also want to invest, because once you file a complete specification and you also file a PCT or a patent cooperation treaty application, right? There's very limited scope for amending the patent. You cannot add anything new to it, right? So if you haven't thought through the details and you still haven't spent enough effort on drafting a very solid patent application, which can hold good not only in, say, India, but also in all the other countries where you're going to apply, right? I wouldn't advise filing a complete specification. So make sure the complete specification is drafted thoroughly. And especially if you also plan on filing it abroad and you want to file it as a PCT application. So then you file this complete specification. Then there are some forms you have to file: request for early publication, request for expedited examination, right? And then if you file a request for expedited examination, you'll get a first examination report typically in about 6 to 8 months. And then you have to reply to that examination report, overcome the objections. And typically in the Indian Patent Office, you have something which is called a hearing, where the assistant controller will have a video conference with you or your patent attorney, and you can explain the invention, you can explain how it overcomes the objections. And if they're satisfied, and also you can make a final written submission within 2 weeks of that. And if they're satisfied, they'll grant your patent, otherwise they'll refuse it. So in India, there's only that one opportunity after the hearing, right, where a decision is given. Whereas in the US, you can actually keep filing what is called as a request for continued examination. And you can keep going through these iterations, right? So there are plenty of opportunities to once again amend your patent claims and present arguments and all these things. Whereas in India, right, once it comes up for a hearing, you don't have a chance to amend it much. So finally, I'd like to introduce my own firm, Mariage IP. So as we mentioned, we have got more than 100 US patents granted for our clients at a success rate of 92%. And we have expertise in helping our clients get patents in all the major jurisdictions, including the US, Europe, Singapore, Australia, China, Canada, Japan, South Korea, etc. So that's it from my side as far as the slides are concerned. If you have any further questions, you can reach out to me. My email address is there, arjun@myipstrategy.com. Now I'm going to turn it over to Radhika.
May I interrupt, Arjun? There were certain questions in continuation with your presentation, so probably we could take some of them now, if that is okay. In the Q&A, Arjun, are you able to see the Q&A part?
Yeah, I can see it. Yeah, sure. Yeah.
So people are asking for a database is probably the first question. Where can you search for country-specific patents?
Sure. So one resource you can look at for some of the major jurisdictions is free patents online, right? Or you can search on Google Patents. But if it's a very specific country, you can go to the intellectual property website of that country. For example, for Singapore, you can search for IP Office of Singapore and you'll find the patents there, right? So Rakesh, should I answer all of them? I can answer quickly, or
Yeah,
should we do it after Radhika's present? Huh?
Maybe quickly, since it is
Sorry?
related to your presentation, maybe you could quickly answer them.
Okay. Yeah. So how do you know if your patent has not been infringed? Yes, the answer is you have to monitor it. Nobody else is going to do it for you. The patent office is certainly not going to do that. So yes, you can do that. I mean, you just have to keep searching on a regular basis. It's called an IP watch. I have data that I have used to file a patent. Can I publish using the same data, or you have to wait? You can publish it, because once you have already applied for a patent, right? If you publish it also, it doesn't affect your chances of getting the patent. You don't have to wait till the patent is granted. If I can justify my patent claims to be different from other similar patents, then what exactly is remaining to achieve? So that's what I said, that FTO and you getting a patent are not, they're very different things. So if you getting a patent just means that you have got a delta improvement over what is existing. But that's a difference, because FTO is on your product, whereas a patent is on an invention, right? So your product may be using certain features or components which may be patented by other people. So, I mean, that's a more complex topic, but I think I've answered the question briefly. Does patent filing need laboratory data or pilot scale demonstration? Well, you need to actually demonstrate to the patent office that there is some technical effect, there is some improvement, there is technical advancement with respect to what is there. So whether you show it through like actual like experiments, or you've got simulations, there is some data you have to provide. If you don't have it, then you can file a provisional and you can add the data at the time of filing the complete patent application. So then if I have several patents, I file a product that is MVP. Do I need to file PCT for all? Can I reduce costs and file the one I'm commercializing? Yeah, I mean, there are a lot of factors to consider in terms of prioritizing your patents. So one thing is like, if all the inventions are going into the MVP itself, right? Then if you haven't applied for a patent, then you may lose the right to patent it. So you've got to, but then suppose MVP has only a few of those inventions, right? Then you prioritize the one which is actually being launched, and you launch those features one at a time. You don't need to launch like in the first version itself, all the features, right? So you can prioritize on that basis. You don't need to file PCT for all. You can decide to file only in India, or you can file only in India plus US, or you can select a few countries. You don't need to file PCT for all, right? So PCT versus US filing, like PCT, it gives you more time. So if you want to file India plus US, you got to file in the US within 1 year. But then if you file a PCT, you get an extra 1.5 years to file in other countries. So the question is like whether you just want a US patent, or you want to keep the option open to obtain patents in other countries. If I have filed for a patent, then is it okay while publishing a paper not to disclose saying a particular product or algorithm is patent pending and publish the outcome? I mean, the paper doesn't have any restriction, right? So basically, you can I can't answer the question on what you should include in the paper. But if you have already applied for a patent, then even if you disclose whatever is there in the patent application, it doesn't affect your chances of getting that patent granted. So anyway, your patent is also going to get published. So I don't think you lose out anything by disclosing the same information in the paper also. Unless you plan on getting the patent also and the publication also and a trade secret, in which case you can leave out certain crucial maybe algorithms or certain data ranges and so on, and keep them as trade secret and not disclose them either in the patent or in the publication. Then finally, one question says like, okay, how long it takes to do a US patent. So you can get it as soon as 1 year if you file a track 1 expedited examination, right? Otherwise, it can take 3 years or so. Please advise if startups or individuals should go ahead with free patent search engines or done with the help of patent attorneys. So basically, I mean, if the cost of the patent search is not very high, right? Then it's actually cheaper for you to pay somebody to do it. If you're going to spend like 50 hours or 100 hours on doing a patent search, right? It doesn't make sense to do it yourself. You have to think how valuable is your time, because a patent attorney may be able to do the same thing in 5 or 6 hours. At what stage valuation of patent makes sense? I would say once the patents are granted and there is some data in terms of the commercial, you have actually commercialized some of it and you have some projections which are reliable. It makes more sense, because otherwise it's mostly speculation. If you have some commercial data, right, revenue and all that, it's the valuation is more likely to be accurate. I think I've answered most of the questions that kind of like variations, what kind of research, how do I customize the product? I answered that question, what kind of research, what are they investing on? You do a search, see what other people are trying to patent. Components purchased, used in a product which might be patented. Yes, it will create, it may be patented by another company, it may be patent infringement. You don't need a proof of concept, but you need to be able to describe your invention through drawings, examples, use cases, and try to provide some data in your patent application. Proof of concept is not necessary to apply for or get a patent, right? So I think I have answered on it. The cost associated with US filing. Initially, you budget around $2,500 at the time of filing, end to end around approx, right? 4 lakh rupees, it's around $6,000. All right. So that's it from my side. Thank you.
Thanks a lot, Arjun. I'll now request Raddhika to take us through the non-patent versions of IP.
I'll do that. Is my screen visible?
Yes.
Perfect. So good afternoon, everyone. Now I'm going to be covering on the non-patent parts of the intellectual property. And that was a very interesting session by Arjun. So, and I'm also going to do some justice now. So if we look at it, IP, like Arjun shared earlier, there are different types of intellectual property. You have trademarks, you have copyright, you have designs and patents. So when you're starting off, a lot of you have asked that how do I know what kind of IP is there, and what do you have to look at it when you're trying to do an IP audit? So what you need to look at is that in your company or in the business that you have, first, you need to identify the intellectual property that you already have. So let me just run through the basic intellectual properties. So one is trademarks. Trademarks is your brand name, the name of your startup, the name of your company, any logo associated with it, any slogans, taglines, the domain name that you have. They all come under trademarks. And trademarks basically help a customer associate the brand with the products that are being offered by the company. Then you have copyright. Copyright vests, there are different types of copyrights: literary, dramatic, musical, and artistic work, sound recording, and cinematograph films. If you look at a technology startup, copyright could vest in the software that is being developed, any technical innovation that is the software that's being developed in a copyright, any literary manual that you have along with the software, any diagrams that you have, all of that can be protected by copyright. Designs is if you have any innovative and unique aesthetic features that are there on a product which are being developed by you, that can be protected under the Designs Act. And patent, as Arjun has already covered, it's an innovative idea which is novel and has an inventive step, it's not obvious, and has industrial application. So these are the different types of IPs which you need to look at whether your business has this or not. So first and most crucial part is to identify the IP assets that vest in your company. Now, if you look at, a lot of people want to know, a lot of startups, they want to understand that why should I invest my money in safeguarding my intellectual property? What is, why do I need to invest right now? Maybe I can do it later. Now, let me tell you, why is it important to register your IP and what are the advantages that you have? First thing is, when you register your IP, whether it's a trademark, copyright, patents, or a design, it gives you exclusive ownership and right to use your intellectual property. It's a source identifier. People know that this particular product is owned by your startup. Okay, and it is a quality assurance that, oh, if it's coming from this startup, that means this product will be of a good quality. For example, if you look at an Apple computer, the moment you see the name Apple or you see the logo, you know that the computer will be good because it comes from Apple. It's a source identifier, plus it's a quality assurance. Second and very important part is enforcing. A lot of you have asked about enforcement of IP. What if you want to stop anybody from infringing your IP? So when you register your IP, it becomes easy for you to stop third parties from exploiting or using your intellectual property without your exclusive permission. So that is the legal right that you get the moment you register your intellectual property. Then another extremely crucial part is commercialization. So, startups are investing money in registering their IP, trademark, copyright, patents, designs. You invest a lot of money. Now, what we advise is, don't just invest and leave it there. Look at how like Arjun said, how to generate passive income. How do you use your intellectual property to generate money and value for yourself? So you need to look at strategies to make your intellectual property generate income for you. That is where you could take advice from attorneys who can help you understand the different aspects of commercialization. You can go for licensing, you can go for sale, you can go for cross licensing. There are so many options that are available. Now, fourth, and which is an interesting part, is access or raise finance for your business. These days, the government is also allowing startups to monetize their IP assets through sale, licensing, or using them as collateral for debt financing. That's also an important aspect where you can use your intellectual property. Now, I'll just go bit by bit on some of the IPs. Trademarks. So we will look at how you can secure, enforce, and commercialize your trademarks. Trademarks is nothing else but your brand name, your the logo that you have, the business name that you have. A lot of people also come up with a question of, how do I come up with a brand name? Why is, they'll just pick up any brand name and they'll just say, okay, let's look at a name which describes our product, so it's or service, so it's easier for us to reach out to the clients or to reach out to the customer. Well, that's the worst thing that can be done, because the strength of a trademark lies in the fact that it should not be descriptive. Your brand name should not describe your products or services, should not describe the nature of the product or service, or the intended purpose of that product or service. It should be something unique, a coined word. That's the strongest trademark, which has no meaning. If you look at it, Kodak is a strong trademark. Why? Because Kodak has no meaning. So if tomorrow somebody comes up and starts selling Kodak shoes, Kodak, which is into cameras, can sue them, because they are trying to ride on the goodwill of Kodak. And how did they come up with a name which has no meaning? Always conduct a pre-filing search. This will help you to see if you are adopting a trademark which could infringe a third-party right. Or are you adopting a trademark which is similar to a brand that already exists in the market? So when you do a search, you get an idea of that is this a unique brand name? Is there someone that's already existing in the market? Am I going to be infringing any third-party right? Or those are the things that you get to know. File application in relevant classes. A lot of people will say, oh, file in all 45 classes. No, it doesn't make sense. You need to identify which is the product or service, which is the category of goods or services in which you should file your trademark. If you're into IT services, it'll be class 42. You don't have to go into anything else. So go to people who will guide you properly and help you understand which are the relevant classes for you. No point filing in everything. So you need to be very strategic in how you are filing your applications. If your mark has been used, file an affidavit. Identify other countries in which your trademark has to be filed. Please do not go and file in all countries. You need to have a strategy, which are in the next 1 year, which are the countries in which you're planning to launch your product or service. Then, there is something known as Madrid Protocol. Use the Madrid Protocol, and within 6 months, file in India, and within 6 months, file in the other countries. You can designate other countries in which you would want to file your trademark application. So strategize and then go ahead. Once you have secured your trademark, look at how you want to enforce it. That can be done by doing a search periodically to see if anyone in the market. This can be done on IP India website, where you can do a search for your brand name in a similar class, and you'll get to know if anybody else has filed a new application which is similar to your brand name, and you can send legal notices to them. Or if they are infringing, then you can, if you want, you can file an opposition if they've got advertised, or or initiate litigation. We do that for a lot of our clients. We help them watch the trademark journals, and which are published every week, and we let them know if there are similar marks which are coming, and if required, send them legal notices or file an opposition, and help them develop a proper strategy for enforcing and safeguarding their brands. Commercialization. Now, your brand is extremely important. Tomorrow, suppose you are into an industry where you can open franchises. So you have franchise agreements, brand licensing, agreements with ambassadors, your partners with whom you can sell the product. And a lot of FMCG products have also gone into brand placement in films. Now, why are these crucial? These are crucial because when you have invested and really protected your brand name and you're commercializing. I have a client who's very famous, and they're into healthcare products for women, and they used all the right strategies. They had merchant partners, sales partners. They also did brand placement in 3 Hindi movies, and they have received funding very recently. And that was all because they secured their IP, they enforced it, and they learned how to commercialize it. Similarly with copyright also understand, if it's a tech startup, your software is very important. And when I talk about software, what you need to look at is, are you developing, is your technology where the software is being developed by you? Is it being developed in-house, or are you outsourcing it? If it's developed in-house, ensure that the people who are developing it, if they are employees, there are proper employment agreements with them. If it is being outsourced, please get a software development agreement signed with the people who are developing the source code for you. Because in India, as per the copyright law, the person who creates the software is the owner of the software. And if you do not sign an agreement where they assign the source code to you, you pay for it, but you are not the owner of the source code. So this is something which every, if you have any software company which is getting it outsourced, getting their software outsourced, please get a software development agreement and ensure that the developer assigns all their rights in the source code to you. Software licensing agreement should be there when you're licensing your software to third parties. Terms of use, be very clear whether you are granting them an exclusive license or a non-exclusive license, or you're selling your software. You need to be very important. Another important thing when you're looking at enforcing, you can also file a copyright application as a literary work to protect the source code. Infringing, you can see, you can find out, keep a lookout if somebody's trying to come up with the software which is similar to yours. And what we also tell some of our clients when they're filing a copyright application for a source code is, try and put an error in the source code which does not impact the working of the source code, but if tomorrow somebody infringes, they will copy that mistake in the source code as well. So it'll be easier for you to prove that they've infringed your copyright. These are some of the tips that we give our clients as well. And another important part is, if you are using any third-party software, please ensure that you take a license. If you do not take a license, they can send you a legal notice and they can actually impose a huge penalty. So companies like your Microsoft and Adobe and all, they are very particular about their softwares being used with license. So respect IP. You want people to respect your IP, you need to respect their IP and ensure that you use software which is legal and which has been licensed. And similarly, you also ensure that no one is using your software without a proper license. Design is similar. You just need to, if you have a unique product which has an aesthetic appearance to it or an aesthetic representation, file a design application. One thing which is important for design is the application has to be filed before the design is launched in the market. That is an important aspect to be kept in mind. And similarly, you can keep a lookout for infringing designs, and you can send legal notice, you can file litigation. Commercialization, again, you can tie up with other design companies where you can collaborate, you can license your designs to other companies. And these are some of the things. And another important aspect of like, why are we talking about commercialization of IP is that tomorrow when you're looking at funding, those are the aspects which will attract an angel investor or a VC to your company. That what sets you apart from other entities is that you have not only secured your intellectual property, you are also actively enforcing it, and you are also commercializing it. So when you go with a product which you know how to commercialize to an investor, they see that you're already investing and you're already looking at how to commercialize your IP, and that gives them more confidence in your company that you know what you're talking about. Now, from an IT perspective, always have terms of use and privacy policy. This is from an IT perspective. Information technology, it is mandatory as per the Information Technology Act that every business which has a website or an application to download, they have to have terms of use. This is a legally binding document which sets the rules and guidelines that users must agree to and abide with for using your software. And it safeguards your interest where you put in the way the person has to use it, not use it, what are the indemnification clauses, disclaimers, warranties, all these aspects get covered in a terms of use. Privacy policy is you need to let your users know what kind of information are you collecting from them. Is it personal, sensitive personal? Who will use it? Who will you send it to? Who will it be disclosed to? All these aspects get covered in terms of use and privacy policy. Now, the last slide, when you're going for funding, what is the checklist that you must have from an IP and IT perspective? This is purely from an IP and IT perspective. See, do you have a brand name? I'm sure you will, because you're launching a product or your service and it comes under a name. If you have a brand name, logo, or a tagline, have you safeguarded it? Have you filed a trademark application to protect it? Have you conducted a pre-filing search? Do you know the exact classes? Have you protected and safeguarded your company in respect of all the products and services that you're offering? Do you have any software product service? Are you a content-based company? Have you filed the right copyright applications? Have you ensured that your source code is owned by you? Similarly with the design, if your product is an aesthetic appearance, have you filed a design application to get a benefit, added benefit for your company? So for 10 years, you can actually exploit the design, 10 plus 5, sometimes you also get an additional 5 years. Can you use it and commercialize it in your interest? Do you have terms of use, privacy policy for your mobile app or website? These are some of the checklists which are necessary for you when you go for funding, to show the investors that you know the importance of IP, and that if they invest in you, they will have an advantage because they're investing in a company which knows how to commercialize its products. So this is what I would like to end with. If you have any questions, you can reach out to me at radhika@aletheialegal.com, and this is my number. So that is all from me. I'll just, yeah. Thank you.
Thanks, Raddhika. I think there's one question. They wanted to know about trademark promotion in films.
Okay, so trademark promotion in films, what happens is that you have, if I'll take some names. For example, there is this company which is into hygiene products, which is called PSafe. It came in Toilet Prem Katha. So there are companies which help FMCG products, startups to get connected with these film producers. So I know a couple of them who do that. So they became their brand promoters. And in Toilet Prem Katha, you can see Akshay Kumar picking up the product and showcasing it everywhere. Then there was another product called Mama Earth that came in a movie with Koichilin and Kalki Koichilin, where she's talking about how to take care of children. So, product placement really helps because And that is the company where I was talking about, where they got a huge, I can't disclose the amount, but it was one of the biggest, because they're still in talks, one of the biggest amount that they got from investors, and it's quite high. Why? Because they got a brand promotion in a film. So yeah, there are people out there, and if someone is looking at connecting, let me know. I can connect you with people who can connect you with these people who do brand promotions through films. Yeah. Any other questions? Okay.
Thanks. Also, there's a question on this is what we received in the application registration form. Patenting of softwares. You know, a lot of innovations coming up in AI, ML. What would be the right approach in applying for patents in such innovations?
Yeah, Rakesh, so actually there is no exclusion on patenting AI ML related inventions, even in India. So it is possible to get patents on AI ML related inventions in most of the countries around the world. So I believe you had featured Niramai Health Analytics, right? In one of your power hours, right?
Yes, yes.
So basically Niramai Health Analytics, let me just share my screen. I thought it would be of interest for some of the people in the audience to see the kind of patent portfolio that Niramai has built, right? There's 40 pending applications worldwide, all granted patents in the US, right? So many granted US patents, EP, European Patent Office, PCT applications, Japan, right? These are the ones which are available on free patent online. So basically, these are all patents which have challenges in patentable subject matter. So there's a combination of software, there's AI/ML, there's diagnosis, breast cancer screening. Despite that, we have been able to get these like 10 patents granted in the US, and a lot of them are going to get granted in India also. So I hope that that convinces you. If you are skeptical that you can't get a patent related to AI or ML, so the answer is that we have been there and done that.
Thanks. Thanks, Arjun. Also, there's another question on if there are any modifications in a patent that has to be done, how do they go ahead with that?
Right. So I saw that question. So it was like, so basically the answer little technical. I need to talk about the patent claims and things like that. So you go through the existing independent claim of the patent and you see like what each element in that claim, right? Whether you can find an alternative for that element. Can you replace it with something else? Can you remove it, right? So that's how you can look at making improvements. So something which removes the requirement for number of steps or number of components can make it more economical, can make it more efficient and things like that. And then you can make further improvements by doing the same thing on the dependent claims also. So that is one you can look at it. And you can look at all the parameters that are important in that invention. So there could be a trade-off, right? Typically between speed, efficiency, processing, it could be between cost, right? A lot of such factors. So if you change one factor, the other factors get affected. So these are some of the things you can tweak and you can make improvements.
Right. There are also certain questions which has come up in the meantime. Can we look at that as well?
Right. So there is a government scheme for patent and trademark registration, right, where the attorney charges are taken care. So yeah, as far as trademark is concerned, Raddhika can answer that. As far as patents are concerned, so personally, right, I have taken a decision to not enroll as a facilitator under Startup India. So the reason for that is that then we have to be compensated by the Startup India. We cannot bill the client directly for our professional services. And there is a cap on the fees. So to give you an idea, right, like for the entire patent process for filing and all that, so the facilitator gets paid, like once the complete patent is filed, I think some 10,000 or something like that. And once the patent is granted, another 10 or 15,000. So basically the amount of time and effort that goes into this, right, as a professional with somebody with so many years of experience, it doesn't make business sense for us. So we are actually doing this as a business, right? So if you want to do charity, we'll do it separately. We don't need the government for that.
So yeah, I think most of the questions we have answered as such. Yeah, another question on PCT, is it better to file it as a company or as an individual?
So if you file a PCT application as an individual, there is a discount. So you save on the government fees quite a bit. So you can enter national phase in the respective countries, and then you can assign the patent to your company. So that works as a strategy to save on cost.
Right. I think we have answered all the questions, I think, which are here. And that is quite commendable in the short time that we had. Thank you so much, Radhika and Arjun, for this session. And some of them have asked for your contact details as well. So maybe you could pull up that slide, or you can tell or type it down onto the chat if they want to get in touch with you.
Yeah,
we could do that. And in the meantime, I would request everybody to fill the webinar feedback form. I will just share the link. I've already shared the link in the chat if you could fill that. And also the recordings of all our webinars would be available on SINE YouTube channel. Do subscribe. And thank you so much, guys, once again for your time. And we look forward to being in touch with you.
Thanks a lot.
Thanks a lot.
For this opportunity.
Thank you. All
Thanks,
right.
everyone.